Well, welcome everyone to the wild and wonderful world of the HIPAA final rule. We're glad to have you join us here today on a Google Plus Hangout. And here with me in different parts of the country are two wonderful colleagues in this field. Brian Ahier, did I pronounce that right, Brian? I communicate with you in writing all the time. But,
right, it's Ahier.
Ehr, excuse me, Brian Ahier, who works as a health IT evangelist at Mid-Columbia Medical Center in the Dalles, Oregon. Brian's also president of Gorge Health Connect, a health information exchange organization, and he served until recently as a city councilor in the Dalles, and currently serves on the board of True Life, an intergovernmental agency providing broadband capacity to the region, and on the board for the Oregon chapter of HEMS. You can find Brian on Twitter at Ehr, A-H-I-E-R, and he also blogs at ahier.blogspot.com. Now, Deven McGraw, who is also joining us, is the director of the Health Privacy Project at the Center for Democracy and Technology, where she focuses on developing and promoting policies that ensure individual privacy as personal health information is shared electronically. She was appointed by Secretary Sebelius to serve on the Health Information Technology Policy Committee, and she chairs its she chairs its privacy and security.
The Tiger Team.
The Tiger Team, yes. And she's also on the Leadership Council of the eHealth Initiative and on the steering group of the Markle Foundation's Connecting for Health Multi-Stakeholder Initiative. She blogs at cdt.org, and you can find her on Twitter at Health Privacy.
Thanks, David. And let us introduce you then. For those that don't know him, David Harlow is a healthcare attorney, consultant, blogger, and speaker based at the Harlow Group in Boston, Massachusetts. He has 25 years experience in the public and private sectors, and this affords him a unique perspective on legal, policy, and business issues facing the healthcare community. David is adept at assisting clients in developing new paradigms for their business organizations, relationships, and processes so as to maximize the realization of organizational goals in a highly regulated environment in realms ranging from physician and hospital relationships to data privacy and security to facilities development to social media strategies and the avoidance of fraud and abuse. He is a charter member of the External Advisory Board of the Mayo Clinic Center for Social Media and the Public Policy Chair of the Society for Participatory Medicine. He blogs and tweets at HealthBlog, that's Health, B-L-A-W-G, and you can check out his blog at healthblog.com.
Thank you, Brian. Now, we'll all be blogging and tweeting about this new rule for quite some time. We certainly have enough blog fodder here to last us a while, so please stay tuned to our blogs. And if you're interested in reading the whole rule, it's been linked to here and there and everywhere, but you can also find it directly at j.mp/HIPAA final rule. That's HIPAA in all caps, final rule lowercase, no spaces. j.mp/HIPAA final rule. So we are going to get into the meat of the issue here, and we encourage you all to reach out to us online if you have any questions that you'd like to address. And Brian, what's the best way for people to get those into us?
Well, there's in the Google Plus feed, there is the ability for people to post comments. For instance, as we were running into problems with my plug-in and getting Deven plugged in, and people were making lots of comments. That's a great place to have a conversation. So if someone had specific comments that they wanted, and if we miss them during our conversation here, we can always go in and post comments afterwards as well.
Great. So
now, David, I really look at you and Deven as some real national thought leaders in this area. So I'll be keeping one eye on the comments as they come in, and probably throwing them your way as soon as I see some interesting questions.
Great. Well, we're gonna dive in with the final Omnibus HIPAA rule. There are really about 4 different pieces of this, or possibly 5, depending on how you count them. And this comes up in the context of the High-Tech Act, which included the push for electronic health records through the Meaningful Use Program. So, to my mind, the additional protections for privacy and security were offered, if you will, as a counterbalance to the broader use of electronic health records that may have raised the hackles and concerns of some folks as they see more and more data being put online. And that is sort of the general context here. And then over the past several years, we've had a number of draft regulations, interim final rules, and so forth being issued piecemeal, dealing with bits and pieces of all this. And we've had the privacy rule, the security rule, the breach notification rule under the High-Tech Act, enforcement provisions, and the ever-popular GINA-related provisions, which really, I think, come in under the privacy rule in order to promote appropriate connections between existing sets of regulations and sort of making sure that they all jive. And probably the biggest change from the drafts that came out earlier is part of the breach notification rule. I'll let others dive in and take issue with me on that. But most of the other provisions in the rule that we see here today have in fact been published as proposed rulemaking, as interim final rules over the past several years.
Not marketing.
Not marketing.
Yeah, marketing is quite a change from the proposed rule.
So Deven, what's in your view? Because I noticed you had mentioned this earlier online, and how is the change? What's the significant change from what was in the proposed rule to what came out in the final rule? And do you think, because I know you watched this pretty closely, do you think that some of those changes were the result of the comments that were submitted on the proposed rule?
I do think that changes are due to comments that were submitted. So for those of you who may remember what's in the statute, it created a rule that basically said that if a patient's information is going to be used to market a product or a service to them, and that communication is paid for by the entity that's manufacturing the product or the service, then it's marketing, except that the proposed rule said that if that communication is a treatment communication, it's not marketing and doesn't require the patient's prior authorization before it can be used to market them. But if it's an operations communication, and they described an operations communication as one that would be, say, for population health or public health, then it would be marketing and you would require an opt-in. And our concerns at CDT were making the distinction between communications that are geared toward treatment and those that are geared toward population health. And a simple example of how hard it is to make that distinction is, what if the communication is going to all of the people with diabetes in your practice, or who have their prescriptions filled in your pharmacy? Is that a treatment communication, or is that a population communication? And that, it's very hard to distinguish between, something that is geared toward someone's health, that's treatment, and something that would also benefit an entire population of people. And so we suggested that what Congress intended was to close the marketing loophole and to have communications that are paid for by outside parties using protected health information from a patient be considered to be marketing and therefore require opt-in authorization. And that is in fact what happened in the final rule, with keeping in the exception for drugs and biologics, including generic forms of drugs, for which the communications can come to you without necessarily requiring the opt-in. So, I mean, that's a pretty big change from saying, that some communications are treatment, and even if they're paid for by an outside party, the patient doesn't have the right to either opt in or be able to opt out of them, from heading towards a much broader sweeping rule that says, look, if somebody else is paying for, if somebody who manufactures that drug or produces the product that's the subject of that communication is paying you to send it to your patients, that's marketing, and we're going to require that patients opt in for it. It was a big win, in my view, for privacy for patients.
And that's my take on it too. I thought that this was a really positive thing for really basically the patients to be able to control the flow of their data.
Yeah.
And so, and I just have to warn you guys, you know, we do have an interesting comment from Wes, who says that at times the person who's speaking has the big picture in the middle, like right now it's you, David, so don't make any faces.
Okay.
So one thing that I thought
there's some other some of the other provisions there in sort of the communications. Some are opt-in and some are opt-out. So, for example, some of the fundraising and so forth communications that might come from a provider end up being opt-out.
Right.
And what's interesting is that on the one hand, I think there's been some improvement, as you described, Deven, in terms of protection of individual patients' rights. On the other hand, there's a broader use permitted of protected health information in targeting the fundraising asks that might go out to the patient. So it's sort of an interesting tension there, and their patient can opt out.
Well, I think if you look at the public good that's served from fundraising versus marketing, you know, philosophically to me, it makes a little more sense that I have a broader use for fundraising than I would for marketing products. But that's just my opinion. I'm actually happy that it worked out that way. One thing before you go on, David, I know there's a lot to talk about in this rule, but there's also something that was not addressed in this rule that I was kind of expecting might be, and that's the proposed rule on accounting and access reporting from May 2011. So we're not done yet, even though this is the HIPAA Omnibus and it's time for everyone to get on the bus. I think there's likely still more to come.
Yeah, well, not only that, but also there are provisions from HITECH that require the Office for Civil Rights to develop a methodology for getting individuals whose data is the subject of a HIPAA violation some sort of compensation from you know, any monetary settlement that gets collected or a civil monetary penalty that gets issued. That hasn't even been proposed yet. So, you know, so we have two outstanding things to look forward to. But beyond those two, this is the bus. Yes.
It's always good to have lots of federal regulations to look forward to.
Oh yes. So what would we do without them?
David, I was wondering if you could just, from one thing that I have a lot of questions that I've had, because I work for a health system and I talk to a lot of physicians, and from a healthcare provider standpoint, what do you think are really the significant changes? You know, these are sweeping changes to the HIPAA regulations, and what do providers need to watch out for now?
Well, I think one of the big issues is the creation of the primary liability on the part of the business associates and the subcontractors down the chain, and you can't sort of escape the responsibility with which you handle patient information by subbing it out. And I think there's an existing problem of small providers and small business associates today that still have not yet fully understood the rule, fully implemented the rule, done their own risk assessments, et cetera, et cetera. This is now going to be an absolute requirement, although there is some, there's a cushion of time that's afforded folks to come into compliance. As you all know, the regulation that we're talking about has not even been published yet. It's been, as the feds so colorfully state, it's been put on display. So it's on display, but it hasn't been published. On Friday, it's supposed to be published. It'll be effective 60 days after that, in March, and the compliance date will be 6 months after that, in September. So we're looking at September 23rd as the compliance date for this new rule. Now, as if that weren't pushed out far enough, the date by which new business associate agreements need to be entered into, and new notices of privacy practices need to be sent out to patients, is a year after that. So there's quite a ramp up period here, and the agency is promising to issue further guidance within this time frame to help folks be able to fully implement these requirements as we go. But there are a number of different groups of providers and business associates that are really not familiar with this, as I said, and I think that's really the largest area of concern, because we're bringing in a whole lot more folks under the big tent here. We're not going to throw them under the bus, and we have some time to get people up to speed. What's important to note is that while there's a lot more folks being subject to the rule here, the government is committed to doing a lot more audits. They've said recently that the fines that they collect, and we haven't talked yet about the enforcement section, but the increased ability to collect fines will fund, in part, the audit activity. And once these rules are fully effective and we've reached the compliance state for business associates and subcontractors, we're going to have government audits of the business associates and contractors, not just of the covered entities. And so people need to be prepared for that, need to be doing their own privacy and security protocols, need to be doing their own internal self-assessments.
It's really moving, the enforcement is moving from penalty-based to penalty-based and away from voluntary compliance.
Right.
Not entirely. Not entirely. I mean, yeah, I think, clearly there's more going on with respect to proactive enforcement through the audits, but I thought the rule made pretty clear that the Secretary would maintain her discretion to do voluntary compliance, to do informal resolution of complaints in all cases except those where the preliminary indication of the facts says this could be willful neglect, right? So everything with a level of blame or culpability that's below that, there's still plenty of discretion there, but certainly a markedly different enforcement environment than we saw several years ago. I mean, it's even without the rule, the Office for Civil Rights was already beginning to do more in this area.
Yeah, I think
right.
Mr. Rodriguez has been pretty aggressive.
You know what?
We've begun going after the smaller groups as well, the sort of small incidents, breaches of 500 or fewer records, which earlier on was just not the focus at all.
I just don't, I mean, yes, it's much more vigilant enforcement, but the term aggressive sometimes has really negative connotations, as though the regulators are going after people who haven't done anything wrong. Take a look at those settlement agreements. I mean, there has been, the environment of hands-off has led to largely ignoring of responsibilities that have existed for a very long time, or people being quite careless with obligations, and so and now they're getting some people are being made examples of, and it's unfortunate for them, but it's not like you look at the facts of those cases and say, wow, that was a little extreme, for not really bad behavior. I mean, it's behavior beyond what should be expected in an environment where we're trying to build trust in EMRs. Frankly. Sure,
I didn't mean aggressive. I actually am in favor of aggressive enforcement.
All right.
So, Deven, I know that you're a strong advocate for patient privacy rights, and David did a pretty good job of outlining the scope of how this is going to affect providers. What's in it for the patients? Why should patients be excited about this?
I think, those of us who look out on their behalf will probably be more excited necessarily than they will. I mean, when I look at the survey data of what bugs people about misuses of their data, like marketing shoots to the top of the list. So it may not be readily apparent to them immediately, because we haven't solved marketing issues in so many other aspects. Like, you can still be tracked on for searches you're doing online for health on the internet and then be served ads. Like, the HIPAA fix didn't fix that. But in terms of sort of information that you might have gotten from your provider, or might have gotten from your pharmacy, that was mailed to you about a health condition that you had, and you wondered why somebody else knew about this other than your doctor, that's going to stop. And the fact that the breach notification provisions are much more clear, in my view, and much more able to be accurately or appropriately exercised, means that I think institutions are going to have to pay a lot more attention to the security provisions like encryption that provide this sort of get-out-of-jail-free card on breach, and which are going to be necessary to build that trust environment.
So I don't know if you guys can see the thread that's going along, but there's an interesting question that says, can you comment on the provision that exempts those entities that provide transport from BAA requirements? Wes thinks he saw that somewhere.
Yeah, he did. Do you want?
Maybe both of you could take a stab at commenting on that.
Yeah. Well, the idea is generally that not everybody who touches something that contains protected health information is using it, is looking at it. There is the idea that there can be a simple transmission, but for the most part, it's a much broader scope of folks who are considered business associates, as described in the commentary to this rule.
Yeah. I think they've sort of clarified that the so-called conduit exception is pretty narrow, and really only applies in circumstances where, in fact, the service that's being provided is like that of a courier, transport from point A to point B. So there wouldn't be very much access to PHI at all, if only intermittent or random, versus entities that store data. So, for example, a software as a service provider of EMR storage and analytics, or even just storage, would in fact be a business associate, even if their intention is not to view the PHI at all. The fact is they're storing it, and the term storing PHI is now added to the scope of services for which you are considered to be a business associate. And failing to sign a business associate agreement doesn't get you out of business associate status. You are a BA, and in fact then the failure to execute a BAA then becomes a potential
bits and pieces of information on behalf of providers and patients, and may have thought that they were somewhat beyond the scope of these rules in the past.
So one of the questions, oh, go ahead, I'm sorry.
Oh, go ahead, Brian.
Well, one of the questions that someone just asked on Google Plus that I've heard a lot of discussion about, and I've been I'm thinking of writing a post on this because it's an important question, and that's the impact that this is going to have on cloud computing services. And so let's see what the specific question, I'm trying to scroll up here. What will the impact of the business associated changes be on those using or considering adoption of cloud services? And in some respects, there may be little to no impact, depending on what types of services we're talking about and what the architecture looks like. But I think there's probably likely to be some impact, at least some thinking that has to be done around how the new HIPAA rules are going to play in a cloud-based environment.
Yeah, I mean, to me, I think that the clarity around data storage being sort of one of the triggers for business associate status means it's much more clear that a cloud provider in the context of an EMR option is a business associate, and there will need to be a business associate agreement then established. Most of these service providers have sort of license agreements that already have to be signed as a matter of course. Those agreements may need to be modified in order to make sure they also meet the requirements for business associate agreements under the rule, or separate agreements signed, if that's the way that someone wants to go. Would you agree, David?
Yeah, I mean, it's a new analysis that people will need to do. If I can turn to another set of issues, Deven, we've talked about marketing and some of the communications that go on in that context, and another context where privacy protections for patients is of concern is in the research environment.
Yeah.
I wonder if you could speak to that a bit.
Well, there were a number of changes that were made to the HIPAA rules that have an impact on research. And for the most part, what happened in the final rule was pretty much what was in the proposed rule. So I didn't see a lot of changes here. But I think that unlike most of the rest of the HIPAA Omnibus rule, which is directly responsive to provisions in high-tech that were enacted by Congress in 2009, the provisions around research are more geared toward responding to some of the concerns of researchers about the difficulties in complying with HIPAA and the conflicts or the perceived conflicts between HIPAA and the common rule, which also governs federal research, but those rules come out of the National Institutes of Health. So, essentially, they allow for you to combine authorizations that you can't say, authorizations for research that you can't say no to, and that includes when you sign up for a research protocol for treatment. If part of the reason why you're getting the clinical treatment is because of the research, you can't then say no to the use of the data for the research. That's the basis for the treatment, and that's called a conditional authorization. In the past, you couldn't combine that with another authorization for other research uses because the fear was that patients would be confused about what they would have the right to say no to versus what they did have, what they couldn't say no to in essence. And now you are permitted to combine these in one form as long as it's really clear what people are allowed to decline to participate in and what they essentially have to agree to as a condition of participating in the research. And then the other piece is that you are now allowed to have an authorization for future uses of research that doesn't have to be study specific. It can be a more general description of future research as long as the description is rich enough that a reasonable person would, if they found out that their data was used for a particular research project, would have said, oh yeah, I said it was okay to do that, right? So not as specific as per study, but not so general as I allow you to use my data for research generally, right? It has to be a little somewhere in between that in terms of the description. It has to be enough to really be informed. And those are two changes.
And that's helpful. Helpful to the researcher because it frees them up from going back to the well again and again, trying to seek a release or trying to track down a patient who's given a release at some earlier point, but then seems to be unavailable at a later date. So that makes the research process simpler.
Yep.
Yeah.
There's also, with respect to the sale of data for research purposes, there's also more clarity in the final rule about what sorts of costs can be included, and it's a broader spectrum of costs, but you still can't make a profit on selling data for research.
Right. So another area that I think is additionally protective of patients, there's sort of two areas regarding records. One is sort of what can a patient require not be included in a record that's transmitted to a payer. And here I'm talking about the right of a patient to say, I'm going to pay for XYZ out of pocket, and I don't want you, the provider, to send any information about this encounter to my insurance company. It may be some sensitive sort of treatment or diagnosis that the patient is concerned, even though we have all these rules, all these privacy rules between HIPAA and GINA and everything else, we're still concerned about the potential for some negative repercussions if certain types of information show up in a record that's held by insurance company or by an employer. So there's a issue about that. Let me turn this off. So the other issue is the availability to patients of records and the right to get those records in whatever form the patient wants, which is a tremendous advance. I think we're still going to have difficulty because if the patient wants something in a certain form and a provider is technically not able to give something in that form, then the patient and provider need to reach an accommodation. But the point is that you can get stuff electronically, not just as a paper printout. Certainly, this ends up being a flat file, and someday it would be nice to know that you could actually get a rich file with the links to the images and other things that are referenced in the text of a file, although that is actually required in this rule.
Yeah, you know, I think one thing about that is that this really broadens electronic access for everyone. So the Ehr Incentive Program is a voluntary program, and there's some great carrots and sticks in there, but there's many providers that are not participating in that program. So the meaningful use requirements for electronic access and view, download, and transmit as broadly applicable as those are going to be to our system, to our healthcare system, this makes it at least the baseline that you just outlined for every patient in the country. So I think it's a great step in the right direction. You know, I think
step forward. I mean, some of the commenters also were looking for the time frames to be aligned with the time frames under meaningful use, but that didn't happen either. The previous rule under HIPAA was that information needed to be provided within a total of, you could have up to 90 days basically, because you could get an extension. Under the new rule, it could take up to 60 days, because it's 30 days to produce a record, and if you have a good reason for asking for an extension, you can get another 30 days. And this would be, for example, something that's in off-site storage. But basically, you're looking at 30 days to get a record, although in the commentary, the agency says we strongly encourage people to try to do this a lot sooner, and with electronic records, it can be almost instantaneous. So maybe we'll see some movement in that direction. But that's an implementation challenge, as is the other issue that I brought up, which is sort of the I guess you could call it the segmenting of information and keeping some information out of the electronic record. I wonder if either of you have thoughts on that particular issue.
I do.
Hey,
I think that's going to be,
Brian, I'm sure you do.
Tricky. So, you know, that's, while I think it's good, and I can certainly see the reasoning for it, and that it's a good protection for patients. You know, come September this year, I think a lot of healthcare providers that maybe don't have the technical capacity to be able to meet that are going to find themselves in some trouble. That's probably, for me, you know, from a healthcare provider standpoint, one of the most troubling aspects of the rule is that to be able to provide that granularity of consent, which I'm in favor of as a directional, you know, as moving in that direction, that's probably going to be a little bit difficult for some providers to comply with.
Yeah, I mean, I'm not trying to discount the technical challenges, but I actually thought that the way that the issue of sort of data segregation, segmentation in an EHR is handled in the rule was very interesting. I can't, you know, so the place where it came up that I read most recently was with respect to sale of disclosure of information to a health plan, right, when the patient wants to pay out of pocket, and what if it's, you know, part of the record versus more of the record, you know, the whole CCD, for example, and the reality is that HHS essentially said, look, we're not going to require you to purchase segmentation technology, but the fact is that you've always had to rely on minimum necessary rules in terms of what you've sent to payers. So you have to have some way of parsing through data to be able to send the stuff that's relevant and what's not, and, you know, figure it out. Because in many respects, that I think they're arguing, this shouldn't be that new. Now, granted, I think it is fairly new in terms of it being increased enforcement and a very clear statement from both Congress and the regulators that, when patients say, look, don't send this to my payer, you can't do it or you'll be in violation of the rules. I also wonder how many patients are actually going to take advantage of this post-healthcare reform when we don't have rating of people based on individual health status, other than smoking.
Right, I had that same question, and again, I think that goes to the concern about sort of what is the law and what is the reality. There's the community rating requirement. There's also on the GINA front, you don't want to have employment discrimination, and that is certainly not permitted. But the reality is people are concerned that it'll still happen. It'll be called something else. So they certainly don't want that information genie out of the bottle. Problem is, again, how do you actually implement that? And how do you implement sort of the downstream information block that you might want, like a prescription, having to get a paper prescription out of somebody after we've spent years trying to get everybody to do e-prescribing. It's another piece of it. We talked a little bit before about sort of the conduit, and I guess Deven or Brian, do you have anything more to say about sort of who might fit into that category? For example, an email provider, other sorts of conduits of either physical or electronic information?
Yeah, I mean, so I think that the HISP, the concept of the health information service provider that just routes the transaction from point A to point B, such as what's contemplated with respect to use of direct, could in fact be a conduit in circumstances where they haven't agreed to take on additional service levels. I think dependent HIEs, I think most of the time provide a level of service above and beyond, mere courier, but there may be some that exist that in fact just facilitate the transactions from one point to another, and they may be able to rely on that exception too. But I don't want to close Brian out from talking about this particular point, but your mention of email made me remember something that's in the rule about communicating to patients that I want to make sure we don't forget. But we can come back to it.
No, go ahead, Deven. I'd love to hear that, actually.
Yeah, so one of the things that they clarified is that if you, as a patient, ask your healthcare provider for an electronic copy of your record and you say, email it to here's my email address, and it's an unencrypted email, the provider is not prohibited by HIPAA from doing that because it's unsecure. In fact, as long as they say to you, alert you to the risks that it's an unsecure communication, and as long as they have,
of the risks.
But if you're like, I hear you, but it's way more convenient for you to just email me, so send it to me, like a very clear statement that the patient's right to get their data in the form or format that they want trumps the security requirement, because it's about me and it's about the data that I have a right to. And if I want it unsecurely notified about the risks, not in gory detail, I can get it.
Right. As Dave says, give me my damn data. Of
course, they can take 30 days to get it to you. But,
right. There's one thing with that, though, that I've read through that section and thought, how heavy is the burden? The requirement for me to explain what those risks are.
I think it's low.
If I just say, that's risky.
Yeah.
That's risky.
Somebody could grab it.
Yeah, go ahead. I take risks every day.
Yeah. I think it extends merely to, if I send it to you by email, there is a risk that someone else could see it, either because the email on your end is not secure or the transmission in between is not secure. I do have a secure way for you to get it, but if this is more convenient for you, I will do that. Document it.
Yeah. I think the concern there, one of the concerns there is that in addition to the security issue, there's always also a continuity of care issue. And if there are these offline conversations and back and forths going on via email that don't somehow end up back as a note in the electronic health record, then something is lost.
Yeah, but David, you can't do it provider to provider. You can only do it provider to patient.
No, I understand, and that's why that's how folks have these secure portals, PHRs, and they'll message patients back and forth that way. Part of the benefit to that, beyond the security, is that the messaging gets incorporated into the electronic health record for continuity of care purposes. So there's got to be a fix for that to capture the email conversation and bring it back in to the record in some way so that continuity is not lost.
So but I think for the HIPAA rule basically says if I'm a patient or my mom's a patient and I have power of attorney and I want a copy of her records, an electronic copy of her records, and I want them to email it to me to my Gmail address as an attachment, then they can do that. And they should do that if that's what I want. If I'm not worried about those records, the transport and the security of those records, and I'm not expecting any clinical messaging to take place, just simply that I receive a copy of the records. Now, if we start talking about some bilateral communication or bidirectional communication between the provider and the patient, then we certainly enter into a different realm.
Mm-hmm.
Fair enough. Yeah. And I think, in terms of sharing of record information, this is more of a clarification than something new, but I'm glad to see this clarification.
I mean, it's important to have it clarified. I agree with you, David, that this has sort of always been the right interpretation of HIPAA, but way, way, way too many providers are telling patients, no, I cannot send you that by email. HIPAA will not allow me to do that.
Mm-hmm. Yeah.
Wrong.
So in terms of clarity, we've gained some clarity, but there's still the whole realm of addressable standards in the security rule, for example. And I think one of the commenters at least said, please let's make all these addressable standards mandatory. Let's get over this. Why not have greater clarity and predictability here? But the feds want to maintain the flexibility, and there is no decrease in addressable standards, I should say.
Well, I'm a big, huge fan of the promulgation of standards, but at the same time, I think to codify them in a regulatory process like this might actually inhibit the development of some of those standards. So a lot of the work that Deven and the Tiger team have been doing and the things that are happening in the standards and interoperability framework, we don't know necessarily where these standards are going to wind up in the future. And so I think that the rule appropriately provides some flexibility there. I don't know what you think about it. I know, Deven, you know quite a bit about standards. So.
Well, I mean, certainly in terms of sort of the need for the security rule to remain flexible to some degree, to take into account innovation, to not kind of hardwire in today's security technologies, and to account for the fact that my sister-in-law who does transcription on the side maybe shouldn't be required to meet every single security addressable specification as a requirement when she's just part-time, doing this stuff versus, a BA like, the Rochester Rio, right? I mean, big difference between those two organizations, right? Is it really the right approach to say same data, same level of sensitivity, everybody has to hit the highest bar? I think it's that creates a set of issues that I don't think the regulators were necessarily willing to let loose on folks. And then in terms, of course, of data standards, it's always standardization is key to, whenever it's key to interoperability, then we really have to focus on it. But when it's not, we have to, I think, always ask the serious question of, does everybody have to dance to the same, do the same dance, dance the same drummer? It's a terrible metaphor. I need to come up with another one. Is it really necessary, again, to hardwire in something and to force people to use something, especially when they're not already using it? And there may be some issues there. So continuing. It'll be an endless conversation, and it started way before I started doing this work, and it'll continue long after I stop.
Right. We're coming up on the top of the hour in about 10 minutes, so I wanted to just highlight a couple of other things, specifically the changes to the enforcement rule and the significant fines that are available to the government to impose in cases of willful neglect, and also the breach notification rule, the new standard that's used there. So briefly on the enforcement side, the bottom line here is that there's the opportunity for a fine of up to $1.5 million per breach, per violation. They're aggravating and mitigating factors, and we've already seen some significant fines assessed in the past year or so, and I'm wondering what the other folks here think about the likelihood of even greater fines in the future. I mean, my personal opinion is that some of the fines, one of the largest fine assessed to date was assessed against a company that was basically bankrupt. So it didn't do a whole lot of good for anybody. I'm wondering what you expect to see in the future.
Well, I think it sent a message, and but one thing I would like to just say at the outset is that, because of the broadening, basically, of including business associates being directly liable, and the way that the rule makes data breaches, more incidents are actually reportable now. More types of incidents are actually reportable. We're likely to see the increase in the number of breaches reported and in the number of fines. And in some cases, for egregious action and the extent of the fine. But one thing that I want to point out is that this is because we're actually reporting breaches. This isn't because all of a sudden, having digital health records and providing greater interoperability and data liquidity is putting patients' information more at risk. I actually think there's less risk. We don't hear about the many misdirected faxes and all the breaches that occur, when someone can peek at a paper chart and there's no way to audit that, and we don't know who actually looked at a paper record. But we know now with our digital healthcare system who's looking at what, and we know when breaches occur, and now those breaches are more and more going to be reported. So we're likely to see an increase in reported breaches, but I'd caution everybody that that's not necessarily a bad thing.
Yeah. I also think that because we're now a bit into the reporting of breaches being implemented, that more and more organizations are catching on to the need to encrypt data at rest in media. I call it media that can walk out the door or walk out of your car or be taken from your purse or left somewhere. Portable media may be another way to put it. That's a lion's share of most of the breaches that have been reported, and there are simple sets of solutions that are technologically available for that. Use secure off-site storage that where you don't store the data actually on the device, or encrypt the thing. I'm seeing more and more attention being paid to the use of a security measure that's always been addressable, not necessarily required, but some organizations are paying out big in terms of hit to their reputations, as well as the costs of ameliorating a breach and the notice, and people are recognizing that, I think, and it's making a difference even before all these, the most recent changes that are in the final rule. So.
Were there changes from the interim final rule to the final rule that you noticed regarding enforcement?
Well, I mean, the one thing, there were a few. I think it tracked, the change in the breach notification standard obviously is a big one that folks are aware of. And, I defer to David if he saw some things in the enforcement rule that surprised him. I didn't really see anything that surprised him. One sort of set of provisions that in the preamble that I was pleased to see is that the direct liability of business associates does not turn them into covered entities, meaning they don't have all of the rights under the privacy rule that a covered entity does. Their right to use data is expressly limited by the terms of their business associate agreement, which also extends to sort of what they can be directly liable for versus what they're then contractually liable for. And I think people just have this assumption, BA, they're responsible for all the same things now as a covered entity. Why do we even need a business associate agreement? Why do we even sort of worry about the relationship between those two entities? It's essentially turns HIPAA into a data protection law, and in fact it does not. The BAs have some liability directly, but they're also subordinate to covered entities, and there are some things that covered entities can't, sort of get out of just by, in terms of their own liability, just by taxing it to a business associate, and it's important to remember that.
Yeah. Yeah, there's a little bit of unclarity in the statutory language, which the agency went to some lengths to explain in sort of the different stages and different amounts of fines and the use of aggravating and mitigating factors. That's sort of a technical issue in the statutory language. I think, as Devin's been saying, the idea of encrypting material is very important because it's important to think about avoiding these sanctions in the first place, and other things that you can do in terms of avoidance. And as a lawyer, I always like to say I practice preventive law, which is appropriate in healthcare. But the audit that you can put yourself through, the comprehensive policies and procedures that you can adopt, the staff training that you can do, will all build together with some of the technical solutions like encryption in order to make these breaches much less likely. And with the time that we have left, I really want to just touch on this big change to the breach notification rule, which maybe is worth a whole other hour, but we don't have that right now. We've really moved away from this harm standard, right. And do you want to speak to that, Deven?
Yeah, I was, on some level, I think that it clarified what the agency initially meant by harm, right? Which was never to sort of open the door to subjective judgments about the value of the data and whether someone would be harmed by it, either economically or with respect to their reputation, but rather an assessment of, well, what happened in this breach, and did anybody actually, who wasn't supposed to get the data, actually view it? With the presumption being that if it's a loss or a theft or there is a breach, that in fact you have one, unless during your investigation you can show that there was a low probability, in fact, that the information was compromised in some way. And so I think some people are going to say, well, that's sort of like a harm standard. It is and it isn't. What's taken off the table is this notion that, well, if it's information about your big toe or the fact that you were in a hospital on a certain day, that's not harmful in some way versus what happened, did somebody see the data who wasn't supposed to without some subjective value judgment about the underlying data?
Right, and there's also the notion that if something gets faxed to Dr. X instead of Dr. Y, maybe not such a big deal because Dr. X is a healthcare provider subject to HIPAA and has treated you on other days. So there's maybe less of a concern about a breach of protected health information in that case.
Yeah, I mean, for me, that was always covered by one of the exceptions, right? Like, just as long as they don't then use the data, go on to use the data inappropriately, or they destroy it or return it. It's the oops exception, right? It's from one covered entity to another covered entity, and as long as that mistake is handled appropriately subsequently, then it's okay. If the data is then used, so that you can talk about the patient at a cocktail party, one would hope that wouldn't happen, but that's not excused just because you're a healthcare provider and you got it intermittently.
Right.
Rarely happens.
The standard, just to be clear in the reg, is that if there is greater than a low probability that PHI was breached, then there needs to be a notification.
Right.
And you determine whether that happened by conducting an investigation. Covered entity has to conduct an investigation. And there's a four-pronged, at a minimum, set of standards that need to be looked at, or questions that need to be examined in reaching that conclusion. Or what's interesting to see here is that the reg also says, if you know this has been breached, you don't have to tie yourself in knots to do a four-prong investigation. You can say, yes, there's a greater than low probability that PHI was breached. We're just going to move right along to the notification stage and not bother ourselves with the investigation.
So I just, we were just about out of time, and I know everybody's got a busy day ahead of them. The one thing that I've noticed from this rule that's going to have an immediate impact on all healthcare providers and business associates that have to comply with this are the HIPAA notices of privacy practices that are going to need to be revised. And so these are posters that have to be reprinted and new forms that have to be created and run through the process for all these different healthcare organizations, and that's a bit of work ahead of them. And so I'm glad that they gave until September, and I think that'll probably be the first order of business for a lot of healthcare organizations.
Right. Yeah, undoubtedly. But you don't have to give me a new form to acknowledge with my signature if I'm not a new patient. Just stick the new poster on the wall. That's
Sure, but I do have to create a new form because hopefully I'll continue to get new patients.
Yes, absolutely.
Right. Well, Deven, Brian, thank you very much for joining in this Hangout on Air today, and thank you everybody who's been listening in and watching and commenting along. I'm sure we will all have more to say in the coming days and weeks and months about these issues, and I invite you all to engage us in conversation online and continue the learning together. Thank you very much.
Thanks a lot, you guys. Well, this has been a lot of fun, and there's been some pretty robust comments on the Google Plus page, so I just posted a link to that on Twitter, and I actually just learned a lot as we were trying to get this Hangout up and running. And I think that we should do this again. We could do future Hangouts on different topics, or even more on this topic as the rule begins to be implemented. So really appreciate Deven and David having a chance to talk to you guys today.
Yeah, thank you
for the great idea and putting this all together.
This has been great.
Bye, everybody.
Bye-bye.
Bye.